大家好，欢迎大家来参加这次美国2023年最新专利实务发展以及 PCT 专利申请介绍。我们今天很荣幸可以邀请 Davis Wright Tremaine 两位专家来到我们这边演讲。那今天的题目呢，主要涵盖的3个领域。第一部分领域呢，是关于如何避免专利侵权的策略及其影响。那在这一次的这个简报当中呢，讲者会告诉您，就是说完全如何避免专利侵权是基本上是不太可能的。但是呢，我们可以去减少风险，例如可以去做一些检索，然后或者是说呢，去在这个当初订定合约、采购合约的时候呢，可以去在合约上面做一些担保的条款 （indemnification clause）。然后呢，如果说你有能力去做反诉的话，有一句话说就是攻击就是最好的防御。如果你可以做 counterclaim， 那可能对手也会被你所震慑，而不太敢轻易的去发警告信函给你。那再来就是说，我们也许可以就是考虑到说，如何去避免一些额外的损害赔偿。因为在美国专利法里面有规定，如果是恶意侵权的话，有可能会到3倍的损害赔偿。那这个时候，如果的话，你可以得到一些律师的正面的一些意见譬如说是不侵权的 legal opinion， 或者是说 invalidity 的 legal opinion。这样的话呢，可以在某种程度上面，在法院上面可以去尽量避免有承受惩罚性赔偿这样的风险。当然，这些详细的部分，我们讲者会有非常精彩的介绍。那在第二部分呢，其实也是非常我们非常夯的，也就是最近非常热烈。大家如果说有在投资股票，都知道说，只要你股票上面呢跟 AI 有关的，那个股价可能就大涨。那这次呢，我们的第2位讲者 Jack 这边，他也会是针对 AI 的这个领域呢，也就是与发明权和专利资格相关的最终人工智能发展相关的专利议题，来向大家做介绍。那在这一个题目当中呢 ，Jack 他会针对就是AI 是不是可以成为发明人，这个也是很争议的议题。在稍早在澳洲等等一些国家呢，有一些驰名的案件，在 Jack 呢，他也会做一个非常详细的介绍。然后再就是AI 它是不是属于电脑软体的一种？那它的可专利性，还有它的这个一些专利性的要求 enablement 的要求呢是怎么样的？在 Jack 呢，他也会做一个非常详细的陈述。那当然最后呢，他们也会告诉我们说，针对这样子的AI 的领域的这个题目 subject matter，我们要怎么样去写好这样的一个专利说明书这些对我们特别是这些做 prosecution 的同仁领域的同事呢，会有很大的帮助。那在最后的一部分呢，我会去来介绍这个 PCT 申请案。那 PCT 的申请流程呢，其实它是一个很好的机制，可以去帮助申请人做他全球性的这个专利的规划。特别是当这个申请人呢，他有比较长远的打算，希望在全球做专利布局，然后呢，希望他的这个在考量费用上面呢，或者是说相关的这个策略上面呢，有比较充裕的时间去做整体的规划。那详细的内容呢，我会做比较更详细的介绍。那我们今天呢，就首先第一个题目的部分，避免专利侵权策略及其影响。那我就欢迎我们今天的讲者来这个替我们做演讲 ，Scott Adams please.
Thank you, everyone, and thank you to Lee and Lee for having me here. So this is This is me. I'm a partner at Davis Wright Tremaine, focus on patent portfolio development. And that includes kind of a holistic approach where we advise clients on how to run programs in order to develop robust IP to protect their business and help them succeed. The technologies I focus in are cloud computing, information security, so cryptography, blockchain, fintech, and medical devices. So what I'm going to talk about today is something that clients ask me about all the time, especially new clients. Very often, clients come up to me after they've received a large amount of investment because they have an exciting product or service that they're going to release, and they come to me and they ask, hey, I need you to do some work to make sure that we don't infringe any patents. And I'm going to go through what I tell them a little bit later in this presentation. For example, I'm going to tell them how difficult that is actually to do, and then what strategies they can take in order to do that and reduce the risk so that they can operate their business effectively. Then there's some other topics I'm going to touch upon, such as damages mitigation. So, if there is patent infringement, how can you reduce the amount of damage that will occur? And then for the patent attorneys out there, I'm going to talk about some drafting and additional considerations that are relevant to the topics 1 through 4 up there. So one thing to consider first is the value of IP for a company's business, especially a tech company. If you look here, we have some examples of some verdicts in the last few years for some patent lawsuits in the US. As you can see, it's fairly rare, but it does happen. You see verdicts in the billions. In 2020, there were 2 in the billions. There was 1 in 2021, and in 2022, there was 1 that was almost $1 billion. You can see some other ones in there that are several $100 million. So you can see why this is an important topic for companies, especially companies that have established themselves and are doing a lot of business. So the first major question is how to avoid patent infringement in the US. And this is a question, as I mentioned, that clients come up to me and naively ask. They say, how can I avoid infringing everyone's patents? And I answer them, you can't. And that's my answer. We're done. The fact is that there are a lot of reasons why you can't avoid patent infringement. And in fact, probably on your way to work, riding a taxi, looking at your phone, logging into your computer, you probably yourself have infringed many, many patents, and you just don't know it. But there are protections in place, and that's why it's not a problem. Some of the things to consider is patents usually publish 18 months after filing. That means even if we were to consider every patent on earth that was in public to avoid infringing them, we would only be able to see the state of the world 1.5 years ago. So if your company is in a hot technology area, this means that you do not see any of the patents that were filed within the last 1.5 years. And in fact, in the US, some patents can remain secret until they are issued as patents. This can be many, many years. In fact, last year I had a patent issue. It was filed in 1998. Theoretically, this one didn't, but theoretically, that patent could have remained secret from 1998 until 2022. So you can see how it's an imperfect process avoiding infringement. And also, something to consider is that a product or service typically involves numerous technologies bundled together, right? If you have an app, a mobile app, right? There's the phone to consider. There's the app itself. There's the servers that run the app. There's the technology that is involved in routing communications between the servers. There's databases. There's everything together. And even a phone has, you think about it, has complicated things in it, many engineers working to build each little part, from the housing, the screen, the processors, sensors, memory, operating system, antennas, all of these things. All of them are constantly being patented by the companies that make these small components. And in fact, people have asked, how many patents are involved in an iPhone? And the answer here is kind of buried there in the slide. The number of patents in a phone is so huge that nobody has ever been able to count, right? And that's just the phone itself. It's not the servers that power the apps that are running on the phone or anything like that. Now, big companies like Apple, IBM, Samsung, they file a lot of patent applications, right? These are the companies that keep patent attorneys busy every day, right? They're constantly innovating. They're constantly coming up with new things in many different areas because their products are very complex. Apple has 70,000 patents. And since the beginning of 2022 has filed for 4,500 more. Samsung has filed for more than 18,000 patents. And you can see that when a company comes up to me and says, ensure that we do not infringe any patents, why this would be difficult and expensive to do. And one of the reasons these companies are building these large patent portfolios is because not only do they protect the innovations, but they're a money-making tool for these companies. They help the companies out in many different ways. One is the obvious way. If somebody uses your invention, you can sue them in court and get damages or maybe stop them. But there are other ways. Sometimes they run licensing programs. Sometimes they sell them. Sometimes they use them as a tactic for scaring people from entering certain markets. There's a lot of things companies do and why they build these major portfolios. And just looking at the iPhone itself, somebody has tried to count, patents covering the iPhone. There were 2,285 granted in 2022 alone. I don't know how they actually came up with that answer because that would be a lot of work to check every single one of those 2,285 patents, but it's probably somewhere around that number. But companies engage in licensing, they sell their patents, and for a company like Apple, they do this because of many different reasons, right? There's the book value of the patents. So Apple's accountants, they will list the patents on their balance sheets as assets of the company, right? They're also positive for marketing. Consumers like to see that things are patented because it shows that there's innovation going on and there's something special about these products and services. As I mentioned, it instills fear in competitors. We have had clients that have just wanted to do something and then decided not to because there were too many patents and by companies that were enforcing them. And there's also things that Apple can do, like defensive publication, so that they can prevent others from patenting things that they're doing, even if they didn't want to patent them themselves. And basically all of this results in an IP arms race, right? Big companies are building these large portfolios because they are afraid of the other companies coming at them with their patents, right? And the idea, it's like the Cold War mentality, right? You have to build a big military in order to prevent the other side from using their military, right? It's kind of how it works. A company like Apple, I like to use Apple as an example, mostly because everyone studies Apple. So there's a lot of data. You can put together slides with statistics that show you what's going on. But this is their litigation for the past 5 years, and you can see how it breaks down. And you can see in this breakdown, you can see that patent is a really big component everywhere you look. As you can see, there seems to be a declining trend. I think the reason for that is probably pandemic related, I'm guessing, but probably some other reasons as well. For example, there was some changes in U.S. litigation law that made it harder to file lots of little different lawsuits. But you can see it's still a major part of what Apple does in terms of their litigation department. So I mentioned that you cannot avoid infringing patents. It's just impossible, or at the very least impractical. So a better question to ask, and this is how I steer clients, is to ask the question how to reduce the risk of patent infringement, right? Because no matter what you do, you're going to infringe. So you might as well put your resources into putting yourself in the best position possible. And I like to think of it as you take a categorical approach where you, one, look at inventions, right? What is your innovation? What is your particular innovation? And you look at patents that are relevant to what you are doing. And I think that's the most straightforward one. That's what, when clients come to you asking how to avoid infringement, that's what they're thinking about, that first category. But as I mentioned, just looking at that category is not gonna give you enough, because you're probably going to infringe anyway. So the next category is you want to be competitor focused, right? Who is most likely to sue you for patent infringement, right? If you are making an app for a phone, you are probably not going to get sued by Intel for the processor used on that phone, right? So you want to look at who's making similar apps, who's competing with you, because it's your competitors that are going to be the most likely that are going to use their patents against you. And so when you're searching for patents to avoid, you want to look at those competitors and what are they doing? What have they patented? And then finally, there's technology focused. You want to look at the core technology. So this is a little bit broader than the first category, but you want to look at specifically, the core technology and see what companies are suing for patent infringement in that area. And one thing to keep in mind here is when I say companies, it's not only operating companies, but you probably have heard of patent trolls, right? So you want to look at who is suing in this area, because patent trolls, for example, will acquire patents in a certain technology area and run licensing programs. And so you can look forward and see what patents are being asserted by those patent trolls and make sure that you can avoid them if possible. Sometimes these patents are very vague and difficult to avoid, and sometimes the portfolios are very large, but you can really look there to get a lot of value with the searching that you're performing in order to avoid patent infringement. If you do these things, you're not going to guarantee that you will avoid patent infringement. You probably won't, but you can guarantee that you can increase the chances of not being sued greatly. So the next question is, if you do infringe, what can you do about it? Can you reduce your costs or damages in litigation? And one thing in the US that is important to know, and I think some other countries have this as well, is that in the middle of the statute, which you don't have to read on there, you can just look at the underlined part, but this is about patent damages. And what this says is that patent damages are no less than a reasonable royalty for the use made by the invention by the infringer, together with interest and costs as fixed by the court. And then this next part is very important. In either event, the court may increase the damages up to 3 times the amount found or assessed, right? So that's very important, because you saw on a previous screen the size of some of these verdicts for these large technology companies, right? A lot of them were, for sure in the millions, many in the tens of millions, and quite a few in the hundreds of millions. When you take those numbers and multiply them by 3, that's a lot of money, right? So it's very important to make sure that you are doing things in order to prevent the court from increasing the damages up to 3 times. So the question is, well, why would a court do that? And they can only do that when, you can see here down at the bottom of the slide, the infringer's conduct is willful, wanton, malicious, bad faith, deliberate, consciously wrongful, flagrant, or indeed characteristic of a pirate. What does that mean? That means basically the infringer's a bad guy. The infringer knew about the patent and infringed it anyway. The infringer looked at the patent, understood that it was probably a valid patent, and went ahead and did infringement anyway. Now you may think that, why would a company do that? Because, and the reason is a lot of companies, or at least a lot of the business people in the companies, don't know about this. And so, you might see, engineers talking to each other and saying, oh, we infringed that patent, and then it's not privileged communication, and so the court finds out, and then it looks really bad, and this can cause the judge to increase the damages by quite a lot of money. So one important thing to do is get an opinion of a lawyer if you think you might infringe a patent. This really helps to prevent the judge from increasing the damages. And the reason is that a judge will think that you are acting reasonably if a patent attorney looks at the patent, analyzes it, and tells you you don't infringe, or the patent's invalid, or both, right? If you tell the judge that you paid a lot of money to a lawyer to look at this in detail, and the lawyer said that you're okay, the judge isn't going to think that you're a bad person, bad company, and increase the damages. But it's not going to guarantee that that doesn't happen. So you can't just pay a lawyer to come up with a not believable theory on why you don't infringe or something like that. It needs to be reasonable. And another thing you can do to avoid the risk of infringement, or at least the risk of the damages caused by infringement, is through indemnity. So if your client is obtaining services or technology from another company, those agreements should include indemnification clauses, so that if your product infringes a patent because of the thing that they supplied to you, they will be responsible for the damages and not you. That puts the burden on them to do the searching and to make sure that what they are offering you does not infringe. Now, they should also do the very focused searching that I talked about earlier in the presentation, but the indemnification clause in those agreements will help you out in that case. Depending on what you're making, this could be like chips or sensors, glass, memory, things that often that a company doesn't make themselves, but buys from other companies. And including services. It can be software as well, like cloud services, database services, whatever you might find that might be used in your product. And one thing I like to tell clients too is that it's very good to build defensive patent portfolios. It's very common among software engineers to not like patents, right? So software engineers, they come up with some great software, they start a business, and they think they want to be, philosophically, they don't want to get patents because they're against patents, they're anti-patent. And from a business perspective, there might be some value in that, but it also is very risky behavior. I think, and a lot of companies will say that they don't want to build a patent portfolio because they think that they're never going to use their patents against somebody. They're never going to sue somebody. They just want to operate their business, and they want to succeed based on the merit of the product they are selling. Now, one thing you see from time to time is companies that do this, and then somebody steals their technology. And at that point, I think there's regret in that type of philosophy. So what I tell clients is that it's important to develop a patent portfolio even if you don't think that you are going to sue somebody. And the reason is for defensive purposes. A nice little catchphrase that I used to have when I played American football as a child is the best offense is a good defense, right? If the other team can't score, that's just as good as you scoring a lot yourself. And it's kind of like the Cold War mentality that I was talking about. You're less likely to get sued by a competitor if you can sue the competitor yourself, right? And I think these companies that have this philosophical aversion to patents do not have that aversion when somebody has stole their technology or when somebody has sued them for patent infringement. So I think that they can actually have these portfolios and still kind of keep those core values that they like. And when this happens, when a competitor sues you, having your own portfolio gives you increased negotiation leverage. So often, a company will say, you infringe my patent and you owe me millions of dollars. And it's very good as a company if you can say, we don't think you infringe your patent, but even if we did, we have our own patents. And so maybe we'll just do a cross license and we can go away and not pay each other money, or maybe I'll pay you much less money than you originally wanted because we could sue you with our own patents. So this decreases the settlements amounts, and it creates more certainty through cross licenses, right? If you can negotiate with your competitor a cross license, you're more certain, at least for the term of the license, that you can operate your business without interruption. Just a few statistics here to show you how companies are doing this. You can see that some of these large companies are obtaining a lot of patents, right, in the thousands. Now, most of them, I think, do not actually assert their patents. Most of them use their portfolios defensively. I don't know on each one. But I do know IBM, for example, does assert theirs offensively. If you have a client that has been successful and is well known, then I am sure that that client has received a letter from IBM about their patents, right? It happens all the time. Intel, I think, is another one that does that. But other companies, they don't. They just build these portfolios and they do not intend to use them unless they have to. And you can see that 14 out of 15 companies listed have used their patents to sue others in the last 10 years. Now, I think most of these are probably defensively, right? This company got sued, and so they used their patents to sue back, as opposed to other companies like IBM, which probably sued on the offensive. But you can see that there's a lot of patents in there, and these companies have achieved a lot of value by building these large portfolios. So one thing I like to tell clients, and this is not intuitive for them, is that they need to file their patents strategically. Clients always say, I want to patent my invention. And they want to patent exactly how they do their invention. But one thing I like to tell them is that nobody has ever sued themselves for patent infringement, maybe, at least not intentionally. You could imagine a very complicated company where one subsidiary accidentally sued another, but it never happens, right? Who do they sue? They sue their competitors, right? So you want to think about not how your invention is done, which is important, but you want to think about how your competitor is going to implement your invention, and that's what you want to patent. Now, when you have an invention, you're the first one to do it, so how do you know, right? So I think there's a lot of value in knowing what your competitors are doing, how they do things, so you can work that information into your patent applications so that while the application is pending, if they do infringe, then you have the ability to change your claims and cover how they're doing that and give yourself a much stronger patent. You might not even need to use this, but you at least have it if you need to. And in fact, we work with a lot of clients to build these very, very strong patents where we find infringement while the application is pending. We change the claims to be very narrow, which means they're hard to invalidate, and they are very clearly infringed. And very rarely do we actually sue a company with those patents, but what we do is we have them ready. if we need them. So some things you need to think about here is, when you're building your patent portfolio, think about competitors, file in countries and areas where your competitors are vulnerable, right? If your main competitor is Korea, you probably want to file patents in Korea. If your main competitor is Taiwan, you probably want to advise clients to file your patents in Taiwan. I'm sure that you guys advise your clients to file in Taiwan. But you want to think about not where you are necessarily, but where your competitor will be. Now, often those are the same place. And you have to, think about what competitors are saying. Like Steve Jobs said, we are going to patent it all, right? Because that's how they're going to protect everything. Now, how do you do this? It's a lot of research. I'm not going to go through this slide in detail, but there's a lot of places to look and to see what competitors are doing, right? You can see what their products are. You can look at what they're patenting. You can look at articles they're writing, websites, product advertisements. The first one, patents, I think is very important because if they are spending a lot of resources to patent things, then there's probably a good sign that they are moving in that area. Not guaranteed, but it's a good sign. These patents are expensive. They wouldn't spend those resources if they didn't find value there. Finally, there's some drafting consideration, and each of these topics could be a whole nother seminar by itself. And I could easily put you all to sleep on either one of these subjects. But there are things to think about. Patent eligibility. Often people think of the business idea, but we have to think about what's the technological idea behind the patent so we can patent that. There's some statutes, Section 112 in the United States, that talk about what has to be in the patent. So that's very important to think about. And it's good to work with, if the US is an important market for your clients, it's important to have those considerations in place so that we can have a strong patent that will give us valid claims that we can assert if we need to. With Section 101, avoid business methods, right? If your client has a business method and that's what their important innovation is, work with the US attorney to phrase the patent language so that it is not a business method, but it's a technological innovation. We have had clients so we actually have an AI tool where we put it into the tool and it tells us which department at the patent office the patent application will go to. It predicts. And if it's going to the business method patent office, we change the wording so that it doesn't go there. And we have had clients that took our advice and did this, and they get their patents right away and they get nice strong patents. And we have clients that did not take our advice and didn't do that, and their patent applications are still pending. Many rejection after rejection after rejection. Claims are this long. If you're a patent attorney, that's bad. But it's good to work with the US attorney to make sure that you position the patent application for the most strength. And talking about 112, Section 112 I mentioned, the best thing to do here is not only mention what your client is doing, but mention a lot of different alternatives. And again, this is a seminar, but there's actually an important Supreme Court case that came out while Jack and I were in Asia that talks about why this is so important. So don't talk about in your patent application what your client does. I mean, you do want to say that, but also include a lot of different variation on how to do that. And if you do that, you're going to be fine here. Your claims are going to be clear because you have described how things can be done, and you will pass this particular test. I know I'm running short on time, so I'm going through these last slides a little bit more quickly. But one thing to keep in mind is that for your clients is that patents are valuable assets. You can see some numbers here on per patent, these large values, and there's a reason for this. The verdicts we saw were very, very large, right? And if you have many different patents, maybe 90% of those patents will not be infringed or may be invalid, but you have 10%, that 10% can get you large numbers. And that's why these large portfolios sell for a lot of money, right? It might have a lot of invalid patents, but there's a few very, very good ones that are very, very valuable in there. Some companies, all their value is in their IP, right? And if you don't have patents, you don't have value. And this is all that this slide is trying to convey. I had one client, I really liked it. They had one single patent. That was all they had, and they were bought for $12 million, right? So that patent itself was worth $12 million. The company that was buying them did not care about anything else about this company, only the one patent. And there's some other considerations too, right? You don't have to sell your patents, you can, but you can license them like Nokia did to Microsoft, right? Microsoft bought a license for 10 years. Nokia kept the patents and kept the value that they had. Finally, the takeaways: you cannot avoid infringement, but there are things you can do to significantly reduce the risk. And one of the things that's important to do to reduce the risk is to strategically develop your own portfolios. So I think we'll have questions at the end, so I'll let Jack come up now. But thank you all for listening.
Oh, I just press this one. Okay, cool. Hello, everyone. Thanks for coming to the talk today. My name is Jack Chang. I'm a counsel at Davis Wright Tremaine. I work on Scott's team in the Seattle office, Seattle, Washington. We came out here for INTA in Singapore. So on our way back to the US, we thought we'd make a trip to Taiwan and talk about some hot topics. For example, patent infringement and AI. Just a little quick introduction. Our group at DWT, Davis Wright Tremaine, it's about 25 to 30 patent attorneys, and we all operate mainly. About 80% of our docket is in the AI space, neural networks, machine learning. We have other clients as well, but this is really the hot thing. And you'll see later on in my talk, at least, so our docket has probably grown double, triple in size in this area. And you'll see it from the patent applications and the statistics that in the last 10, 12 years, patent applications in AI have doubled in the US and probably in foreign jurisdictions as well. Like I said, AI, neural network, machine learning, that's our team mainly focuses on that. That's me right there. I do a little bit of other things too, litigation support, some trademark work, but the focus is patent prosecution, especially in this space. We've grown so fast that it keeps us very busy. So that kind of leads in to the parts of my talk here. So with AI, a little bit, I thought I'd do a little introduction about AI and what it's about, the basics. And part two would be the inventorship, whether AI can be an inventor themselves, or the system, or the neural network, or the machine learning model can be an inventor. I thought that's a pretty unique, interesting case, especially in the US right now. There are some countries that have decided upon it too, whether AI can be an inventor or not. But in the US, it's been dragging on. It's a pretty popular case, actually. And there was actually a recent decision last month, I think, and I had to update my slide really quickly last time. But part two of the talk will be a little bit about AI-related inventions and how difficult or it could be in U.S. patent prosecution to obtain allowance on. So I'll go through a little bit about subject matter issues that we see a lot, obviousness, enablement issues that we see from the U.S. patent examiners when we get office actions. And then lastly, some drafting considerations, so a little bit to touch upon what Scott said earlier, how to draft strong patents with AI-related inventions. I think that's very important too, with how we advise our clients and how we do it in the US, specifically our firm, to generate good quality patents for our clients. Cool. Yeah, so just a quick introduction. AI, neural networks, machine learning, they're usually trained on inputs, right? And then over time, they train themselves to understand what's going on, how to generate output. For example, we could train a neural network or a machine learning algorithm to perform object detection or image recognition, or to generate tags or data labeling. So it's very popular in many, many different subject matters and companies and areas of interest, especially medical, speech recognition, medical imaging. We see that a lot. Autonomous driving also uses that a lot. So some of the hot topics applies AI to most of their products and services nowadays. So a lot of companies are focusing on this. A lot of big companies are focusing on that. So our clients are focusing on that with patents. So there's a little bit of a statistic here. I actually haven't looked in 1976 what kind of AI related cases there are, but statistically there was just a little bit of AI, obviously, but by 2018, about 42% of the patent applications have AI relationships or interest in them. I think later on the slides I mentioned earlier, there's double the amount now in the last 10 years. First, inventorship, whether AI can be inventor. A lot of you probably heard about IBM Watson. They have that service or product IBM does, and it does a lot of things, right? It helps you do a lot of things. Also ChatGPT, a lot of people have heard about that too. So whether that can be an inventor itself on a patent application. So a little bit introduction on whether inventorship and how the U.S. At least in the U.S. Determines whether an inventor is a patent inventor or on the application. Under the statutory 35 USC 100, it must be an individual or multiple individuals who invented or discovered the subject matter. Further, there's case law and further statute on this, but the conception is the formation in the mind of the inventor. So you got to think about it, you got to convey it, be able to formulate it, and then to be able to complete the resulting invention. There is case law that in 2013 that inventors must be natural persons, so human beings, people here. So individuals ordinarily understood to be a human being. That's just how we understand this word to mean on a daily basis, even dictionary.com. However, there are additional definitions in dictionary.com that indicate it might not be a human being. I think the third definition in dictionary.com or Oxford says it's a thing or a process or something like that. So that was something that actually what I'm leading into here is Thaler described or talked that they talked about in the recent Fed Circuit and court cases, whether the individual must be a living person or a human. So just a little bit introduction. The most popular case right now is Thaler versus Fidel. Stephen Thaler is the inventor that, or actually Davis is the inventor, but Stephen Thaler was the one that is the assignee on the patent application, but the inventor was Davis, which is the system he used or indicated it created this improved food container. So that's what he's been trying to argue. I think he filed 2 patent applications, and both of them were listed as Davis as the inventor. And the USPTO, the patent office, kicked it back and said, "Hey, this is incomplete. The application's incomplete. The applicant or the inventor must be a person, right?" So he then, petitioned this, and it went all the way up the court system. So here are some arguments he indicated. Thaler did not contribute to the conception. He did create Davis to solve the problem, but it ran on its own, basically, is what he argued. And then when interpreted in the context of the Patent Act, the inventor may include non-human entities. And then the court's response is, humans must be inventors, and the key word is individual. I think he also had some more arguments. Let me see if it's on the next slide. Yeah. So to promote and encourage innovation. So he argued that, it's best to have Davis be an inventor here because what about, creating or making new drugs, right? That promotes innovation. That helps the society. So those are some policy issues that he brought up during the court case that he thought was strong. Another one is 103. He says a patent application may not be denied based on how the invention is made. But the courts respond, obviously it goes back to, it's still an individual. It's got to be an individual. And 103 relates to obviousness. And it has nothing to do with inventorship. I think another thing they raised during the case was 101, the subject matter eligibility, the word had whoever in there. So that was another support for saying that, the individual must be a person, because whoever usually refers to who or whom or a person, right? So that was another thing in there. So the ultimate decision, it went through the district court, the Court of Appeals, obviously can't be, so he actually petitioned to the Supreme Court and it just got denied last month. So that was the most recent update about this case. From the USPTO, from the district court, from the Court of Appeals, everybody at each stage has mentioned that, it's got to be a natural person. It's got to be a human being, like you and I. Let's see. Oh, but however, there were some court systems that did allow it, like South Africa. But South Africa doesn't have a very substantive examination system. I think you can just register it and, they just go through the process, maybe just stamping it and allowing it or something like that. I'm not quite, familiar with South African patent system, but based on the research, they did allow it. So I think many jurisdictions think it's going that way because of this allowance. I've read many articles saying, oh, is AI about to be allowed as an inventor because of this? But as you can tell from other courts and other jurisdictions, that's not the case. I think German federal patent court says no, UK, EPO, all those other countries basically say no as well. But it is talked about, it is going through their court systems as well too. So this goes into part 2 of my talk here. Are AI-related inventions patentable? So aside from the inventorship issue, now we go into the subject matter of the patent itself, right? The invention. If it's related to AI or AI has helped create it, or you've run the program or you trained the model to do something, right? These are AI-related subject matter. And whether it's easy, difficult, or whether you can obtain a patent at all with AI related. The answer is yes. There's been many cases allowed. Like I said, in the last decade, last 10 years, about applications have doubled. So allowance has also increased in this area. It's not to say it's easy. It really depends, I think, on the quality of your patent application and your drafting strategies. And to eventually get to the finish line of allowance. But there are some hurdles, patent examiners, just like us, or perhaps are just learning about this, right? Or just getting accustomed to this. So they're not, some of them, might not be well trained in this yet. So they're learning along the way as well. They're trying to apply the law, apply the policies, but there aren't much out there yet, right? Because it's kind of a new thing. So going through this, I just wanted to talk about what kind of drafting strategies, what we do normally during prosecution with AI-related inventions. So here's a little statistics. AI patent owners, IBM, I think Scott talked about earlier, is big in this in filings, just filings in general. These big companies have thousands and thousands of cases. Obviously, if they're trying to chase the hot thing in AI and machine learning, they're also filing in this space too. IBM, so Amazon is on there. That's one of our clients. We work on a lot of work. We do a lot of work from them. It's not on here yet, but we do work with NVIDIA. NVIDIA is a very big client of ours, and they're kind of pioneering a lot of these inventions in the AI space. So they probably don't have the statistics yet, but I can see it, getting up there really quickly once we work on their cases and start getting them allowed, because we have a lot with them. Yeah, and you can see the trend from 1976. Its percentage now like 28, close to 28. So this is the boring part of the talk, subject matter eligibility. Scott mentioned this a little bit, 101 issues that could come up with AI. A lot of common things we see in the office actions is the examiners determining that it's an abstract idea, because and it also kind of depends on your drafting strategy and your client's your client needs and requirements and wants. For us, we draft a bit broader, and Scott was talking about this earlier, is we want to draft in a way where we think the competitor would implement, right? So of course we want to go a little bit broader to capture that, right? When we do capture or try to go a little bit broader with our applications in the claims, these things come up very common, very consistently with examiners. They indicate, hey, it's an abstract idea. A lot of times they say you can do this with pen and paper, right? You can predict the weather with pen and paper or formulate it in the human mind. The funny thing is, there are examples, and I'll get to that later, is basically saying that it's not an abstract idea, but they're just changing the words around the examiners are to reject our claims, so that I think it's a training thing. I think they're starting to get a lot of these neural network AI related cases, and they say, hey, it's got to be abstract, so that's something we take into consideration when we draft our applications with that. But here's just the few things that come up with the judicial exceptions under 101 I was talking about before. Sometimes we get the mathematical formulas as well, mathematical calculations. The most common is the human mind formulated, or concept formed in the human mind, or can be done with a pen and paper, or pencil and paper. They say, I think some examples I had are like, we deal with floating point operands. It would take forever to do it in the mind or pen and paper, but the examiner thinks you could do it with pen and paper. I think I had other cases. The examiner thinks you could do with pen and paper. Very, very, very difficult calculations. I can't think off the top. I just kind of forgot. But basically, that's how they're operating now, and we see that a lot in our patent prosecution cases. Oh, so how do we combat that? And I use this example a lot. Many practitioners do too, but since I've been in practice the last 8-9 years, and if I ever have a case dealing with neural networks or AI, this is part of the patent eligibility guide from 2019. This was issued by the USPTO, US Patent Office themselves. There's about 50 to 60 examples in there, and example 39 is the only one that talks about, or maybe there might be one other that talks about mathematical calculations, but example 39 is the closest one I try to compare our claims to, because it talks about training, it talks about neural networks, and this is actually something the USPTO issued that said this is subject matter eligible, and I use it a lot, and I like to think that it's because of me the USPTO has started training their examiners on how to combat us and contrast us when we bring this up. I've had I just had an examiner interview last week, and I briefly mentioned the PEG example 39 that I plan to discuss, and he had a whole analysis on it already, on what I was prepared to say, and he tried to combat everything already. He's like, example 39, we recently had training on it. It doesn't work because of this, this, and this. You can't use it because of this. And I said, well, you guys issued it. Your office issued it as subject matter eligible. But if you read the claim, and that's why I like to analogous or make an analogy with our claims, because if you read the claim, the first few elements is really just collecting data or images, collecting data, right? Applying some sort of transformation or change to the data, and then creating training data, right? For the neural network to be trained. And then the second set here is just what you got out of that, and also the additional data from before, and then training it again, right? So, and they deem this subject matter eligible. So like I said, our clients kind of like the broader claims, and when we're in the space, this is kind of how I try to convince the examiner sometimes that this is no different. What we're doing is really no different. Some of our claims don't necessarily say training, but we're using a neural network to do A, B, and C to generate output, which is, I think, in my opinion, very similar. So they should allow it. But like I said, nowadays they have a whole training on it. So I think in the next month or two, a lot of them are going to start talking about it during examiner interviews to try to contradict or contrast my points here. And so why did the USPTO, the patent eligibility guideline in 2019, indicate it was patent eligible? It actually didn't go through all the steps. It kind of stopped. So first it indicated it was a process, sure, but it kind of stopped here and said some of it may be based on mathematical concepts, but they're not recited in the claim. These steps are not practically performed in the human mind. And it doesn't recite any method of organizing human activity, such as managing interactions or formulating an economic concept, a fundamental economic concept. So it stopped there. So it got to 2A prong 1. So like, just to step back here, we got to go through this entire process. Usually when they have issue a subject matter rejection, and then we got to, most of the times we draft responses to say, okay, well, it's not step 2A prong 1 because of this. If it is, it doesn't satisfy step 2A prong 2 or step 2B, right? So we create additional arguments. Even if it does satisfy the first step 2A prong 1, it doesn't do these. We have additional elements that integrate into a practical application. We provide arguments, right? So this example just stops at step 2A prong 1. And many times when I'm discussing this with the examiner, I'm actually saying, hey, it stops here, right? We don't even have to go through the other steps, right? Even if it doesn't stop here, even though the guide says to stop here, that it's patent eligible, we still have the other steps, right? We still have implemented in the practical application, in view of the specification, which I'll talk about later on, but we provide additional arguments and examples. So even if it does pass this point, which it shouldn't, we have additional arguments too. So it should be quite strong, right? All right, and then so after the 101 issues, which we get a lot, if we can get through that, in practice, we usually focus on the 102, 103 rejections first. We kind of a little bit, table it 101 sometimes, but not really. We want to make sure we can get, maybe some claims with the examiner where, we can agree on something where it's not in the art. And then we can kind of address the 101 a little bit later, because, you could go down a deep end, a very black hole with 101 issues, right? It seems and appears very subjective based on the examiner, based on who you get as an examiner, right? So now we get to 103 or 102, 103 issues. Usually, a lot of times we see, and this has probably happened in the past, is you get one piece of art that talks about the inventive concept, and then another piece of art that says AI does it, or here's an AI app, right, or AI patent, so you can combine it. Or in the past, there was everything does the inventive concept, but the GPU does it, right? So same idea here. We get that a lot. But with our clients, I feel like they're pioneer in this space. So I'm finding it, even though if our claims are a little bit broader, many times the examiners can't find the strong art. So we advocate for the claims actually. So we don't amend as much because we want to advocate for these broader claims, which are more valuable for the client, right? In case the competitor were to implement it, right? So that's 103. 112. Sometimes we get some of this as well. But however, and I'll talk about this in a little bit, is with drafting considerations. If we have strong specification and describe it well, usually we won't have a 112 issue. But sometimes there is, because for example, a drafter could just say AI does it, or a neural network, or a machine learning model does it, right? So a drafter may just claim that, right? And then in the spec it says that's what it does, right? So kind of that black box effect. And that's probably when 112 happens. So we don't get this as much because I think we draft pretty detailed specifications to avoid that. Because like Scott was saying, how it's done, how it's being trained, the inputs, the outputs, etc. In the specification would help with this. Would help avoid the 112 issue or rejections. So Scott talked about this before. Consider the art unit. Like I said, we have the AI tool, or Scott said we have the AI tool that avoids business methods, the art unit 3600. The vocabulary we use, sometimes the AI is related to financial considerations, right? Or business or online transactions, right? So we try to avoid those terminologies to avoid the art unit, which is the most difficult in the US, which has the lowest likelihood of allowance, right? So that's a drafting consideration we do with AI related inventions that we definitely need to be aware of. Another one is what we do in draft. This is probably not in drafting considerations, but maybe it is. It's how we explain things in the specification. It helps when we interview the examiner, right? If we draft the application with easy to understand, but also with enough technical details, but upfront we normally do easy to understand or examples or processes of how this inventive concept works in our applications. So that usually helps the examiner understand what's going on. So that's also in our drafting considerations, especially if you have super long patents. Most patent examiners, most readers don't read past the first few pages, right? So it's very important to really nail it and focus on the inventive concept, I think, in the first few pages of the specification. Drafting considerations, sometimes, I look at example 39, but to kind of try to be similar, but like I said, client requirements, client needs, client service, sometimes they want it done this way or that way, so you can't really follow example 39 as much. And examiners are supposed to use these guides as guideposts, but you never know. You never know with examiners. Some more drafting considerations, talking about the 112 issue before, if it does come up. When you draft the applications, you want to be specific with your architecture for the particular application. Give examples of how it's being used, how it's being trained. What's another one? Talk about what type of neural networks are you using. So those are additional considerations. Here's the inputs and outputs, and then. So claims that are, if you're simply just claiming like testing or training or building the AI, those have been a little bit more challenging and difficult statistics-wise to get allowance. So it kind of depends on the client, right? If the client wants to be very specific about what's going on in the claims, then it's okay. Perhaps you add a little bit more with AI-specific architecture or the inputs and outputs. A lot of examiners sometimes just ask, what's the practical application? Just add it into the claim, right? or some examiners indicate, this is just a neural network doing A, B, and C, but is it implemented by a computer, right? Sometimes that just gets us over the hump with examiners. Here's another one. Also, a lot of times, at least with our applications, we want to have, like I mentioned in the first few pages, the technical improvements. I like to call it or many folks call it probably the technical problem and technical solution paragraphs in our specification. So that really just homes in on how what the improvements are, what's the practical application, what it's being used for, how it's processing faster or more efficiently. So I use that. I do that a lot in the first few paragraphs of our specification. For example, reducing the layers, using different hardware, so on. So here's another few things for drafting considerations is computer implement USPTO's examiner training materials. So that would be a useful resource, if the examiners actually follow it sometimes. So yeah, let me see here. So here's some more statistics. Top litigated technology areas it's growing, in the neural network AI space. In the 2020 study, 482 litigations, about 66% were companies in this space. So I finished a little earlier, but that's really the summary of how we take AI-related inventions and AI inventorship issues into consideration when we file applications for our client. Yep, thanks.
现在进入第3个章节刚刚就是2位讲者就是已经讲得非常的充分。那我这边稍微说明一下，在这个这次的研讨会之后呢，我们会提供 PDF 档的这个 PowerPoint slide，所以各位可以用去下载，然后去做比较仔细的研究。那因为刚刚的这两场这个 speeches 内容比较丰富，那就是讲者也是用英文来做呈现，所以如果各位特别是线上的听众如果有问题的话，你可以用中文打出来，然后我们这边会有专门的人员帮你的问题翻成英文来去给这个2位英文的讲者。那接下来呢，我今天要介绍第3个这个单元呢，是关于 PCT 的部分那 PCT 的部分它有许多在申请上的好处，我待会会做一个比较简短的比较详细的介绍。我先介绍我自己，我是孙宝成专利师，那也是专利部的资深顾问。我的背景比较就是比较偏向于机械的领域，包含了机器人、半导体、自动化等等。那在取得资格部分上面，就是我取得比较多的国家的资格，包含了中国的部分，还有台湾和美国的部分。所以在实际操作上面，我也帮客户做了除了台湾的专利侵权分析之外，中国、美国也都做了一些相关的一些案例。那这部分呢，我都做了一些研究等等。那主要部分我还是在做于这个专利申请，就是 prosecution 的部分也就是为什么我这一次的这个第3个这个题目呢，会是跟 PCT 专利申请有关。那在接下来我们就进入今天的第3个主题，就是 PCT 的申请的流程，以及它带给申请人的一些好处。那到底什么是 PCT 呢？那 PCT 它是 Patent Cooperation Treaty， 它基本上是一个国家之间的一个就是合约也就是那就是这几个国家之间呢，就是这些 contracting states 呢，他们之间呢有个约定怎么样去针对专利申请的部分一个统一的流程让后续的国家都可以采用。那目前呢有157个 contracting states， 那基本上我们可以看到下面的图案，就是在全球世界地图上面，几乎主要的国家大部分都已经是PCT 的 Member States。那其实它最主要的概念就是你申请的时候，不会像以前在巴黎公约的时候，可能我们必须要到每一个国家去提出专利申请。那只要经过单一的一个申请案呢，就可以去简化后面的一些申请的流程。然后呢，再接下来之后呢，进入的国家阶段以后，那我们前面的这段部分 PCT 申请部分呢，我们叫国际申请阶段。那真正要取得专利，还是要进入到每个国家之后呢，进入各国的实体专利法的，还有一些实质的部分的审查，来去决定说，由各国的专利局来决定它是不是符合各国的专利要件和专利要求来授予专利。所以基本上分为2大部分，也就是国际部分和这个国家部分。那国家部分其实跟一般的申请案是没有什么太大的差异。那主要是在于国际的部分呢，可以去替申请人节省很多的资源。那这张图我们可以看到，就是传统的这个依照巴黎公约的申请案，上面的部分是 traditional 的部分。那我们可以看到，就是说你申请了第一个专利之后呢，然后经由巴黎公约第4条的规定，主张这个就是 priority claim， 然后在12个月内呢到各国去申请。那下面的是 PCT 的部分，我会看到就是说，他在第一个申请案之后呢，可以再申请就是申请 PCT 主张第一个申请案，然后之后呢，会有一个国际检索报告，然后就是在18个月的时候会公开，然后后面有几项是可以选择，一个就是说你可以request for 那个 supplementary international search， 或者是说可以要求一个初步的这个审查，这是个可选的部分哈。那最基本的就是你会至少会拿到一个国际申请的报告。那这国际申请报告呢，它还会附带一个 written opinion， 就是针对它的检索报告的意见里面，它会有一些书面的意见，告诉你分析为什么每一个请求项他认为是具新颖性、不具新颖性、具进步性或者是不具进步性的部分。然后呢，一直到这个我们可以看到就是说，在28个月的时候呢，就是如果你有请求这个 supplementary international search report， 就是补充检索报告的时候呢，在28个月的时候，它会出去给你。那如果你有请求这个初步的审查报告的话，在28个月的时候也会给你。然后在第30个月的时候，有些国家是大部分是30个月，有些国家是31个月的时候就必须要进入到国家阶段。有一些国家甚至就是说，它虽然是规定30个月，但是你可以如果超过的话，可以就是走回复程序，缴一些费用，也还是可以进入国家阶段。那简单的来说呢 ，PCT 它基本上就是说，它把一些时间给延后了。我们可以看到就是说，一般的申请案在12个月的时候，你就必须要去做这个申请的到进入国家阶段的动作。那其实在进入国家阶段是产生最多费用的地方，包含了翻译费用，包含了这个官费，还有当地的这个local agent， 就是事务所他们的费用。所以你在第12个月的时候就会产生这么多的费用。那 PCT 它呢有一个很大的，我在后面可能还是会再重复，就是说它最大的优点就是它把这些费用 delay 了，一直到30个月后你才可以，即使你是就是有主张一个优先权，那至少有18个月多了一些时间，可以让你去把这个费用去延迟。那为什么要延迟呢？其实有时候我们就是在发明人或申请人在提出申请案的时候，对本身的这个它的专利的可专利性并不是这么了解。有时候一开始的时候会觉得说会雄心壮志，觉得说我这个申请案要申请可能要很多个国家，但是真正的情况之下，像在 PCT 申请的过程当中，它给你很多的一些初步的分析的意见。例如说你在看到第16个月的时候，收到这个检索报告和 written opinion 的时候呢，申请人就可以评估说它的这个可专利性 那甚至说，就是每一个可专利性的这个是不是符合他的需求？那也许他一开始的时候决定要申请的是10个国家，当他看到这个检索报告的时候，他可能开始改变主意的，觉得也许我只要申请5个国家。那相对于在这里，你在12个月的，在相对于这传统巴黎公约这个方式，你在12个月的时候，可能你就钱都已经付出去了。但是你在16个月的时候，你虽然多付了一个 PCT 申请的这个费用，但是你把这时间在16个月的时候，你砍了一半，就是不必要的。它其实节省的费用比你要当初的这个抉择要来的多了很多。那这个 PCT 它这个整个申请的这个最大优点就是说，第一个，你初步检索报告譬如说有些大部分都是负面或全部都负面的时候呢，你可以请求一个初步的审查报告，然后就是在这个拿到这个检索报告的时候可以做修正，然后在做请求这个初步审查的这个过程当中呢，你可以修正你的 claims， 然后它这个就是初步审查意见的单位呢，它会针对你修正后的 claim 再给意见，那所以等于就是说你已经有拿到了许多的意见，可以去做一个很完整的评估，说你后面到底是要进入哪些国家，甚至到哪个国家你的那个每一个 claim 或者请求现在怎么去安排呢，都会有比较好的安排。所以针对特别就是说一些比较重要的发明呢，我们可以利用这样的机制呢，可以节省很多的费用。那当然针对这些其中里面有提到的这个补充检索，还有这个就是初步的这个审查的部分呢，我后面会有比较详细的介绍。那就是说我们来看一下，就是说针对一个国际申请案的话来讲那它的这个目的是什么呢？其实就是取得一个申请日，也就是我只要申请一个 PCT， 我可以到以后各个国家阶段以后，它都会认可这个申请日。一个很简单的一个 PCT 申请案，你就可以确保了之后的进入国家阶段，每个的申请都会是这个申请日，甚至这个你的这个承认的原先的优先权案也会被认可，优先权，只要那个就是针对所有的就是这些 PCT 认可的国家的话，它都会认可一样的申请日。那还有另外一个优点，可能大家就是不是那么重要，但是也是相当有帮助。但是一旦你的 PCT 的申请接受以后呢，你 PCT 说明书的一些申请的格式呢，就不会就是那个国家 PCT constructing state 呢，它就必须要接受这样的格式。那如果你是一般国家的申请案，你到那个国家阶段的时候，它会有很多形式要求，比如说它一定要有摘要或者摘要字数多少。但是你只要是 PCT 案申请进来以后呢，你的字数不符合它规定，它也要接受。即使你没有摘要，它也要接受。如果说只要 PCT 这边它接受的话，你后面的国家就必须要接受。所以你就很可能就是在进入国家阶段的时候，不会因为该国的一些形式上的要求而产生一些多的动作和费用出来。那谁有权利去申请这样的 PCT 申请案呢？就是必须是一个 national 或是 citizen， 或者是一个 resident， 就是有一个居所在那边的这个 PCT contracting state， 这是157国家里面的一个国民或者是居民。那居民的话，就是说可能也许是一个比如说一个营业所做生意的地方，它可能是一个子公司然后它甚至就是说或者是说在那边有经常的一个营业的地方就足够了那当然 national citizen 是绝对没有问题的那针对这个 PT 申请案里面，如果它包含了多个申请人的时候呢，也只要其中一个申请人他符合这个，他是其中一个 national 或是resident 的这个条件呢，就会被接受了就会被接受了。那他当然还是要看你那个 receiving office 因为如果你那个就是你递件的那个专利局它就是申请人必须是那个 receiving office 的 national 或者是 resident 那就是只要其中一个符合就可以符合了，不需要全部的申请人都符合的，它是一个 national 或是 resident， 然后是那个 receiving office 的 national 或 resident。对，那再来我们来看一看就是说你要取得一个 PCT 申请日必须要哪些东西呢？ 第一个就是申请书，当然你们要写申请人是谁等等，然后再来其实是后面的部分，就是我们一般的专利说明书的内容，它必须是要有一个说明的部分，然后要一或多个 claims， 然后这一部分的 drawings 其实就是它就这边有写说 where necessary， 就是因为有一些专利申请案其实不需要图的啦，如果是一般的机械案或者是电子，可能图存在几率比较大，但是有一些生化案件啊，或者是一些方法案，可能它不需要图也有可能的。那摘要是需要的，就是你要取得一个 PCT 申请，它必须要的一个文件上面的要求。好，我们再看看哪一些语言可以被接受呢？重点是在那个 receiving office， 它 receiving office 它可以接受什么语言，你就可以。那以台湾的申请人来讲的话，我们比较尝试就是像中国的国家知识产权局递交的话，它那边基本上就接受是中文跟英文的部分是可以接受的。所以就看你主要是你要向哪一个receiving office 去递件这样子，来决定说哪里的语言是可以接受。当然，如果像 USP6 我的理解就是英文啦，应该是没有其他语言。那然后呢，再来就是说有种情况之下，就是那个 receiving office 一定要接受，就是当你后面指定的那个检索单位呢的语言，指定的语言，还有或者而且那个语言而且同时是这个可以接受的这个公告的语言的时候呢，它是必须要接受的。然后呢，我们来看一下这边，就是再来就是我们申请以后呢，就是要必须这个会有一个国际检索单位 ISA 那 ISA 呢，它是这157个国家里面其中几个国家，因为不是所有的这个国家的这个知识产权局或者专利局，它都有这个检索的能力。那目前为止呢，大概是有20几个国家，那有一些不是国家，是一个区域的这个机构，像 EPO 的部分的话，它也是可以做这个检索报告的。那这边也是我刚刚提到，就是说，如果你选择的是那个 receiving office 里面那个其中的这个 ISA， 就是 International 那个国际检索单位它接受的语言，通常它是一个，而且它同时是一个public， 就是在公告的时候可以接受语言，例如这下面这8个语言其中之一的话，那个 receiving office 就必须要接受这样的语言。那我们来看看一下这边这个就是国际检索单位ISA， 它包含了哪一些？就是这边有看，我们可以说起来，国家大概是有20个国家。那以台湾申请人来讲的话，比较长的就是中国，然后南韩、美国、欧洲等等。但我想大部分还是以中国为主，因为它的语言上是比较方便，可以接受中文。那再来就是说，至于就是说那个检索单位它可以接受语言呢，是由哪一些检索单位可以，就是申请人可以选用，就这些哪些可以选用是由 receiving office 来决定的。receiving office 就是你递件那个专利局，它来决定说哪一些它可以，就是哪一些检索单位它可以采用，因为可以采用。那以那个 CNIPA 那边，就是中国国家知识产权局的话，早期他们只接受他们自己就是 CNIPA， 以前早期叫 CIPO 的这个检索报告，那后来那个EPO 的检索报告他们也采用。那每个国家都有他自己的这个每个 receiving office 它都有自己认可的那个 ISA，所以这些必须要去问你的代理机构问清楚这样子。然后我们来看看检索报告是长什么样子的。它其实就是，其实我们如果有在这个行业做，大家都知道，就那个检索报告里面，它就是列出了很多的前案，然后呢，还有去指示它的这个 patentability 的部分，然后用 X、Y、A 等等的方式来去表明它跟新颖性和进步性之间的关系。我们来看看这个 example， 这是也这个从 WIPO 上面的一个那边把它找出来一个案例那可以看到就是说这边的话呢，它就是这个 category 的部分 那 X 通常就是单一的这个引证的，就可以否定这个 claim 的这个 credibility， 不管是 novelty 或者是 inventive steps。然后是哪一些部分跟这个揭露或者是教示的部分，它会在这个文献的那个，譬如说是在这个日本申请案的第4栏第30行到第27行。然后呢，这个部分 X 有关的是请求，就是1到3的部分。然后就是哪一些请求项对应到它的认定的判断结果是多少。然后呢，这边是说是这个引证案文献是哪一份引证文献，然后它参光揭露的这个内容是在哪些地方。好，这就是一个典型的这个 ISR International Search Report 的这个样本。那我们再来看看，因为 International Search Report 呢，通常会伴随这个 Written Opinion， 它里面呢会有一个很详细的分析，告诉你说它为什么认为它不具吸引性或者不具进步性等等。那这个意见是由 ISA 决定的。所以我们在指定 ISA 的时候呢，是有一些学问因为其实这个 ISA 的这个审查的标准、检索标准，是有一些不同的那当然就是还有是牵涉到是费用的部分。所以申请人在决定你要指定哪个 ISA 的时候，你可能要考虑一下。当然第一个语言的方便性，像中国它是接受中文的，所以它可能很方便。当然也考虑到就是说它的 credibility， 因为这个检索报告它是一个参考的文献，它不是一个 binding 的文献，没有限制性的。所以可能有一些，如果是一些比较不具那个公信力的这个 ISA 出具报告，可能你后续的那个审查那个 receiving office 它审查的时候未必会采用。那我们现在目前为止知道，好像就是公认就是它的那个 credibility 最高的是 EPO 的欧专局他做的检索报告是认为是可信度是最高的，很可能就会被后来的那个 receiving office 在审查的时候呢采用，但是有一些国家的 ISA 可能就不一定会被采用所以我们在选择 ISA 的时候可能要考虑这几点。那就是说它只是一个 ISA 只是一个意见，就是 opinion 那所以它不是一个正式的一个对你的这个专利有一些任何实质上的这个限制，所以你也不需要做答辩，真正的答辩，但是你还是可以做答辩，但是就是一个因为不会有一个真正的一个给你的回应说再去，除非你是做一个初步有请求那个初步的审查，要不然的话你也可以做修正，就是我们会就是 article 在那个 PCT article 19的部分，你可以针对在 ISA 做修正那个做修正是为了以后你进入国家阶段的时候，你可以用你修正后的claim是进入国家阶段，但是你修正以后那个修正到底是不是有超犯或者是说它会不会因为你这样修正而就具有可专利性，那不是这个修正的目的但是而且你同时可以去针对你的修正呢，还有那个前案去做一些意见，那都会列入记录。那这些东西都是你修正的内容，还有你的这个 informal response comments 都是之后的这个国家阶段的专利局或者是这个财产局他们的参考，作为他们的参考之用。那我们来看看这个 written opinion 是长什么样子。那基本上就是它会先列出来，就是说novelty 的部分，他认为哪一些claim是 yes， 哪一些是 no。那 inventive state 的部分也是我们中文进步性的部分，那哪一些 claim 是 yes， 哪一些 claim 是 no。那 industrial 这个 applicability 就是产业利用性的部分，我们通常都看到 yes， 很少看到 no 的，但是可能比较特殊的情况下是有 no 的部分。那再接下来可能后面还有好几页这个当然是前面的部分，它就开始会做一些这个 reasoning 的部分那后面通常会好多页，至少可能2页3页的部分，就像我们收到官方审查意见的这个内容一样，他会去解释说为什么他认为某些请求项不具进步性，某些请求项不具吸引性等等。那我们再看看这个比较少见的这叫做 PCT Supplemental International Search 这就是补充检索。那为什么会有这种需求呢？就是说因为语言的关系啦，因为可能那个 ISA 它只有某种语言检索，所以它检索的前案也是限于某种特定的语言。那有一些申请人他会为了 担心说以后可能在某一些其他语言的文献上面被发现的话，那他还是功亏一篑啊，所以他会觉得比较保险的情况之下，他再请求一个补充检索，补充检索，那补充检索就不会是原来的那个检索机构，然后你甚至可以就是要求就是其他语言国家的这个的检索单位other than the ISA which carry out the main international search 去做一个补充检索。那其实整个 PCT 的申请的流程，这些的文件都是给申请人参考用，都是给参考用。那这样的这些东西都是让你的这个整个的那个检索的内容结果会更完善。如果说你的主要的这个检索报告跟补充检索报告都是正面的话，那相信申请人就会相当有信心，说他的这个专利以后，这申请案到进入国家阶段以后，通常是可以取得专利的。但是这个补充检索报告呢，就是它有一个差异，跟这个就是我们一定会有的这个 main international search report 的差异点，就是在于说它不会有个 written opinion， 它就是一个检索报告，但是它在那个检索报告里面还会有一些详细的说明，但是它这在形式上的差异是这样，就是主要检索报告会有一个 written opinion， 但是普通检索报告不会有 written opinion， 它是一个 optional 的，就是说你可以不要这个没有关系，不要这个补充检索。那接下来这个就是国际的这个初步检查，这个第一个它也是一个 optional， 那其实就是你可以要求一个这个 IPEA Internet 就是 International Patent Examination Agency 或是 Administration 那其实它的这个单位跟 ICA 都一样，就是那20几个单位你可以请求，通常会要求原来的那个 ICA 才去针对你它会针对你的这个修正后的文件再去做一次评估，这就是国际初步审查的它原始的这个它 ICA 给你一个检索报告，你针对人家检索报告，我把 claim 重新修一遍，请你再帮我看一下，那我这样修正以后的可专利性怎么样？那就给申请人又更多的一些资讯去判断说他的 claim 是不是具有可专利性。而且呢，在在针对这个 International Preliminary Examination 的这个部分呢，你做的申请呢是根据 Article 43是 PCT 第43条里面的这个规定，针对前面的那个一般的检索报告你只能show claims， 但是如果是就是你要提起这个国际初步审查的部分的话，你还可以show description， 还有 drawings 也是可以同时修的。所以它可以修正的范围是比较广，相对于前面的这个 PCT 第19条提起的修正。那这个针对这个国际初步审查的是根据第43条那你这些修正的 claims 呢，都可以在进入国家阶段的时候，你要选择用原来的 claim 进去国家阶段，还是用根据 Article 19 或者 Article 43的这个修正的内容进入国家阶段。就可以减少掉一些初步审查进入国家阶段以后还去做一些修正再去审查的这个时间和费用。那这些呢其实都是 non-binding 的，都是 non-binding。简单来说，整个 PCT 的过程呢都是 non-binding， 但是它其实是具有一些相当的说服力，特别当你选择的 ISA 是一个具有公信力的这个机构的时候呢，它被承认的几率就会相当的高。那我们也可以看到，其实有一些我们收到一些审查意见通知书，它其实基本上有时候如果它是国际 PCT 过来的进入国家阶段案件，它有时候会去抄这个 written opinion 的意见在那个里面去，所以我们可以讲说，虽然它是 non-binding， 但是它是就是有很高的 credibility， 而且会被采纳的几率是蛮高的。那当然取决于你选择的 ISA。那进入国家阶段以后呢，就是我们刚刚提到前面的那个流程图看到，就是说在第30个月，有时候31个月，或者是你超过了第32个月，然后去缴一些这个就是回复的这个流程，缴一些费用的话，还是可以进去。那 PCT 它其实就是一个 gateway 让你可以进入到国家阶段。那让前面那个流程呢去统一化，然后给你一个很多的这个机会去评估你的申请案的这个可专利性。那至于说你可不可以取得专利， 因为没有所谓的世界专利，其实它是 WIPO 下面一个架构，每个专利还是各个国家发出的专利。那实质的部分就是关于这个新颖性 novelty 啊，或者是embedded state， 或者是甚至 support 的那些要求呢，还是根据各个国家的要求来决定的啦。最后的决定，这是法律上的程序是这样。但是如果我们刚刚所讲的，如果说你选择的 ISA 是一个很有公信力的 ISA 的话，其实对你后面的这个时间呢是有非常大的帮助的。到底PCT 申请有哪一些优点呢？刚刚再重复一次，就是说单一的申请案然后可以让你去涵盖到全球，几乎全球157个国家的这个涵盖的范围。然后呢，还有一个好处就是 time delay， 你就可以多了将近一年多的时间去做决定。很可能你到30个月的时候做的决定，跟你当初第12个月做的决定是不一样。有鉴于你收到的这个search report， 还有这些，或者是你如果是提求初步审查意见的话，你看到这个检索报告和初步审查意见，甚至补充审查意见的时候，你很可能在进入国家阶段，你要选择的国家就会跟你当初想的不太一样。第三个就是你把这个费用延后了，如果你用巴黎公约的话，你在第12个月的时候就产生那个最大的费用，翻译费用，然后当地的这个事务所的费用，还有当地的官费等等都已经产生了。那利用这 PCT， 你可以把这时间拉到第30个月的这个时间点呢来去产生，然后这个时候可能，而且你已经会做一些改变，有可能增加，有可能减少，但通常减少几率比较大。你可能会增加一些国家等等，发现说你的这个可专利性这么高，而且是同时可以利用这段时间观察市场上的发展，这样的技术是不是在这市面上或者在全球上面被采用的几率很高的时候，来去决定你后续的这个申请的策略。而且在这个过程当中，这个 ISA 出具的检索报告，还有这个国际初步检索审查它的这个报告呢，会给你一个针对你这个发明的 patentability 的很好的一个 assessment 的这个reference， 可以给你一个很好的一个参考。所以 PCT 来讲的话，如果是对重要的发明，我们觉得是，而且打算申请比较多国家的时候呢，其实它是一个很好的机制。最后我们来看一下统计的数据。那这边可能不是那么清楚，到时候你们可能有 PCT 档案的时候，可以再仔细看一下，或者是到 PCT 的到 WIPO 的网页上面，它也有显示。目前为止呢，以中国申请人的这个申请量是最多的，大概有7万件，再来是美国申请人、日本、韩国等等。那目前2022年，因为现在的统计数字就到2022年，有27万8千多件的 PCT 申请案。就这个技术领域，我们来看一下，其实每个国家不太一样。像中国的话，它是以电脑技术，然后电子还有这个数位控制是他们的几个大宗。那但是德国可能就不一样，德国的话，它运输是在第2大类，然后呢，这个量测是它第3大类，因为可能德国它是一个比较偏重机械的大国，所以在技术领域上面跟其他国家会稍微有一些不同，这个供大家参考。再来我们来看看哪些国家它申请的数量是最多的。第1名是华为，所以华为最近他们就大量的开始要找各个公司去谈授权的，因为他们这个5G 的这个专利是最多的，而且最先进。虽然说他们受到一些制裁，在产品上面发展受到一些限制，但是不影响他们在专利授权部分的这个进展。那其他接下来就是包含了三星啊、高通等等，高通就是很有名，就是一直在授权，他们主要的收入其实是来自于授权。那还有其他一些主要是一些日本、韩商或者是美商等等的这些申请人利用 PCT 是申请案是最多的。好，那今天的报告到这边为止。我想就是刚刚可能大家已经有机会利用一些时间把一些问题给提出来。那我们这几位讲者就我们会坐到前面来，然后接受大家的问题，希望大家多多提问。我们现在欢迎任何问题。
Okay, I have a question for Scott. Your presentation have covered most part of patent litigation in the U.S. So could you talk a little bit about discovery and what a role it plays in in U.S. litigation and its pros and cons? Thank you.
So discovery is the process in U.S. litigation where one side can get documents from the other side. And both sides in the litigation have a right to documents of the other side. Now, the amount of documents that each side is entitled to is very large. Basically, any document that might be relevant to the case, unless there's an exception such as attorney-client privilege. In U.S. litigation, sometimes parties will rent warehouses for boxes and boxes of documents they fill a whole warehouse. We're talking millions of documents. Now, in more recent times, there are services that digitize them so they can be searched electronically. But the amount of documents is huge. One thing to keep in mind is that U.S. companies operate with the assumption that any document they produce will be discovered by the other side. Not all documents will, but very often there are accidents because of the volume of documents. And so discovery is a process that you have to think about very early, right? If you have employees talking about patents, you want a patent attorney to be involved in that conversation so that the document is privileged and not subject to discovery. You don't want to have non-lawyers talking about competitor patents because that will be a disaster for the case because there is a requirement that those documents be provided to the other side. And the penalties are very, very harsh if a side tries to hide the documents. The pros and cons, I'll start with the pros. The pros of discovery are that you can get access to things which would otherwise be secret. So if you need to prove your case of patent infringement, you have access to a lot of documents that you would not otherwise have access to because the court will require the other side to provide them to you. That makes the cases a lot easier, especially involving technologies that are very hard to figure out unless you have access to these documents. The cons are that it makes lawsuits extremely expensive. If you have millions of documents, you need lawyers who are charging hundreds of dollars per hour to go through these documents and find things that are relevant to the case so that there can be evidence for the case. And you saw the amounts of the verdicts in some of these patent litigations, hundreds of millions of dollars. You can imagine that companies are spending a lot of money on lawyers to go through these documents to find evidence for these cases. And also a con is that you have to think about it ahead of time because if you are creating documentation that will be harmful in litigation, the other side will have that unless you have involved attorneys to make those documents privileged.
Okay, thank you. I have another question for Jack. Yeah. Your presentation was about AI patents. How do you think about how AI, such as ChatGPT, is going to affect law firms or our work as litigators and patent attorneys? Thank you.
I think we'll be okay. Excuse me. I think based on the history of, there has been services out there actually that have tried to automate patent applications and generating patent applications, at least in the U.S. Services such as inputting, one figure and the specification gets drafted for you. So I think we'll be okay for now. As those services haven't really taken off, one of the primary issues with a lot of these services, and perhaps with ChatGPT, is client confidentiality. So a lot of clients won't agree to use these services because there is the potential that these inventions or ideas get saved in the cloud, right? And people could see it or use it, right? So that's one issue. Another issue is the product. The eventual work product is still not quite there yet, I think. I haven't used it firsthand, but some folks have told me that using ChatGPT, it's just not there yet. And in our presentations, we talked about drafting strong specifications, right? And having enough detail, technical details to avoid issues like 112, 103, 102, 101, especially too, right? So these things are probably issues that it's going to take a while for a system to learn that, if anything. So I think those two issues will be okay for the time being. We'll still have a job for a while, I think, because of the work product and the confidentiality. Those two issues, I think, if that gets resolved, that might be a different story. But right now, I think we're okay.
好 ，OK， 我想我们今天的这个就是视讯会议还有线上的会议就到这边圆满结束。如果大家没有其他的问题的话，谢谢大家的参与，谢谢。